Good morning, everyone, and of course to our AHRC colleagues for hosting this event. It is an honor to be one of the speakers, and I would also like to recognize our counterpart from the Philippine government, the Department of Justice, who has worked extensively and has led refugee protection and statelessness initiatives, along with other government agencies and stakeholders. So as mentioned earlier, I will be presenting the International Refugee Protection and Statelessness Framework. So before anything else, allow us to introduce our organization. So we are called the United Nations High Commissioner for Refugees, not to be confused with UNCHR or OHCHR. We are also known for short as the UN Refugee Agency. So our primary work is to work with states in providing protection or access to international protection and durable solutions for all persons of concern. So within the context of the Philippines, who has taken great steps in terms of refugee protection and statelessness, what we do is we extend technical assistance in upholding its commitments, whether in international human rights law, international refugee and statelessness law, among others, to uphold their state obligations and ensure the protection of our persons of concern and ensure that they are not left behind. So just to provide some context, the UN High Commissioner for Refugees was created in 1950. So this was during the aftermath of the Second World War. And at that time, UNHCR was established as a subsidiary of the UNGA, or the United Nations General Assembly, to help Europeans who had fled or lost their homes. And at the time, we were only to operate for only 3 years. However, as time went on, UNHCR's mandate has been extended through successive resolutions until in 2003, UNHCR was authorized to continue its work until the refugee problem is solved. So for 71 years, I hope my math is correct, we have made it our mission to work with states and relevant actors to ensure that persons of concern have access to international protection and durable solutions. So international protection here would refer to all efforts to ensure that rights of individuals in line with relevant bodies of law, such as human rights, humanitarian, refugee, and statelessness laws, are respected and fulfilled. So when national protection is lost or when governments are unable or unwilling to protect their citizens, people seek the protection of other countries. So UNHCR is mandated to work with states to ensure that they are admitted to the country of asylum, grant asylum, and respect human rights. So recognition as a refugee or stateless person is not an end in itself. It will only end once durable solutions have been attained. So just to emphasize, UNHCR is not a substitute for government responsibility, as states have the primary responsibility for protecting the rights of all people within its territory. And as mentioned, the mandate of UNHCR has expanded to not just refugees, but to other persons of concern as well. So in terms of our work here in the Philippines, but before that, UNHCR has around 135 offices globally, and one of which is in Manila, or the Philippines, which has been here for 50 years. So initially, the office was in Manila, which was focused on asylum seekers, refugees, and stateless persons. And in 2010, UNHCR established its presence in Mindanao to cater to issues on internal displacement. So we'll look into different persons of concern to UNHCR, and you will see also later during the presentation of our colleague from the DOJ how this is applied or being done in the Philippine context. So just to note that in international law, there is a legal definition for refugees and stateless persons, but for other persons of concern, it may not be the case. So one example is an asylum seeker. An asylum seeker is an individual who is seeking international protection. So in countries with individualized procedures, so meaning refugee status determination procedure, or in the case of stateless applicants, stateless status determination procedure, an asylum seeker is someone whose claim has not yet been finally decided on by the country in which the claim is submitted. There is also an important note here that there's a difference between access and recognition. So everyone has the right to access asylum in line with Article 14 of the Universal Declaration of Human Rights. However, there is no guarantee of recognition. So later on, you will see in the national framework and landscape that the Philippines has a joint refugee and stateless status determination procedure. However, in some countries where refugee status determination procedures do not exist, UNHCR assumes that said role. So those that are recognized by individuals as such are considered mandate refugees. But again, emphasizing that the state has the primary role to recognize or protect persons of concern, and UNHCR only assumes this role if the state does not have that capacity or is unwilling to take refugee status determination. So in terms of a refugee, you see here that there is a lot of words. There are a lot of words in blue, so we'll try to break them down. But primarily, this is based on Article 1A2 of the 1951 Refugee Convention and its 1967 protocol. So this definition has customary international law standing. So even states who are not state parties to the 1951 convention adhere to this definition. However, there are instances, for example, the convention governing the specific aspects of refugee problems in Africa, or the OAU convention, and the Cartagena Declaration would further expand this definition. So just to break it down, first is on the well-founded fear of being persecuted or persecution. This implies that it is not only the frame of mind of the person concerned that determines his or her refugee status, but that this frame of mind must be supported by an objective situation. So this means that it therefore contains a subjective, usually through the statement of the individual, as well as an objective element. For example, protection officers would look into the country of origin information in determining whether well-founded fear exists, and thus both elements must be taken into consideration. The specific motive of persecution rules out persons as victims of famine or natural disaster, unless, of course, they also have a well-founded fear of persecution for one of the reasons stated. And persecution, just to differentiate, is different from prosecution. There may be instances that prosecution leads to persecution, especially in instances where there is discriminatory application of the law. So just to differentiate, prosecution is more on bringing legal action, while the persecution is while there is no universally accepted definition, Article 33 of the 1951 Refugee Convention provides that this refers to threat to life for freedom on account of the grounds indicated in this definition. It also includes other serious human rights violations. So agents of persecution may be state authorities or even groups who do not respect the country's standards as may be provided. So it's really a case-to-case basis. The next aspect is on for reasons of race, religion, nationality, membership of a particular social group or political opinion. So these are the grounds by which a refugee is recognized as such. So a person must show well-founded fear of persecution for one of these reasons. So it is immaterial whether persecution arises from one or at least or more than one grounds. So for instance, when we talk about race, this refers to all kinds of ethnic groups, commonly minority groups who are discriminated against. So discrimination is one of the root causes also of refugees under refugee protection and statelessness. religion, there is a universal right in terms of freedom of religion. However, well-founded fear of persecution when it comes to this aspect may mean that prohibition in terms of membership to a religious community, being unable to worship said religion, whether in public or private, among others. Nationality here would refer to not just citizenship, but may also be referring to belongingness or membership to an ethnic or linguistic group. So sometimes it may overlap with race. And membership to of a particular social group would mean persons of similar background, habits, or social status. So a claim to fear of persecution under this heading may frequently overlap with a claim to fear of persecution on other grounds, like, for example, race, religion, or nationality. And lastly, political opinion. This, as stated, individuals who hold an opinion that has been expressed or has come to the attention and is not tolerated by authorities or those agents of persecution. Next is the outside of one's country, of his or her nationality. So this would refer to the country of origin, but for stateless persons or stateless refugees, this would refer to the country of habitual residence. So it is important to note that aspect that refugees must be outside the country of his or her nationality or habitual residence. There are no exceptions to this rule, and international protection cannot come in as long as the person is within the territorial jurisdiction of his or her home country. And lastly, is unable or owing to such fear, is unwilling to avail himself of the protection of that country. So this means that being unable to avail of protection means circumstances beyond the will of the individual. For instance, instances of war, while unwilling would refer to refugees who refer to accept the protection of the government of the country of their nationality or habitual residence. And again, it's important to qualify, it's important to note that it is being qualified that it should be owing to such fear or because of that well-founded fear of persecution. Refugee status is declaratory in nature, meaning a person is a refugee once he or she fits the description or the definition of the 1951 Refugee Convention. An asylum procedure will only verify whether the person's claim of fear of persecution falls within such definition. So not every asylum seeker will ultimately be recognized as a refugee, but every refugee was initially an asylum seeker. It is important also to differentiate a refugee between a migrant. So a migrant, as many of you may know, is a person who, for reasons other than those contained in the definition here, would voluntarily leave his or her country in order to take up residence elsewhere. So it could be personal reasons, economic reasons, and therefore would not be considered as a refugee. However, there is a possibility that economic migrants might become refugees if economic measures are directed towards certain groups based on the grounds set forth in this definition. And you might wonder, what is the difference between IDPs and refugees? So IDPs, internally displaced persons, as provided in its name, they must be within the country of nationality, or as opposed to those refugees who must be outside the country of nationality or habitual residence. Next, refugee surplus. The requirement that a person must be outside his country of his or her country to be a refugee does not necessarily mean that once they have left the country, they are already considered as a refugee. So he or she may have decided to leave the country, but would not be a refugee at a later date due to circumstances in his or her country. So these individuals are called refugee surplus. Although this is not found in the convention or the 1951 Refugee Convention, this definition still applies considering that these individuals are similarly situated as refugees. Stateless persons, they are defined as a person who is not considered as a national by any state under the operation of its law. Similar to the Refugee Convention, this is part of customary international law and is declaratory in nature. This is based on Article 1 of the 1954 Statelessness Convention. And again, let me briefly break down the definition based on those in blue. First is who is not considered or not is within the present context, especially since citizenship can change over time. When we look into national and state, here we look into the links by which the individual has with regard to one or more or no state. So it is important to also consider here the specific state authority who recognizes the citizenship of the individual. And lastly, operation of its law. When we say law here, it does not necessarily mean legislation alone. It looks into policies, decrees, regulation, judicial case law, and how also they are also being implemented. So when we identify or when we assess whether an individual is stateless or not, it is therefore a mixed question of fact and law. So as mentioned, stateless status is declaratory in nature. However, stateless status determination procedures would be important for the state to identify who its persons of concern are. And also considering in stateless status determination cases or applications, it might require inquiries to foreign authorities to verify if they are recognized as a national by that specific state. But in instances where the individual is also an asylum seeker or a stateless refugee, this could compromise the confidentiality and do no harm principle. So in such instances, the refugee status determination proceeds first, and the stateless status determination procedure is suspended. Because for refugee status determination, we do not contact embassies, and also we rely on country of origin information or COI, along with statements and documentation from the asylum seeker. So we also have populations at risk of statelessness. There is also no official definition on this. Although there are literature that would define this, a person who is not stateless, so not a stateless person, but due to their circumstances may become such in the future if preventive actions are not taken. So there are certain groups that could face specific difficulties to establish their nationality. For instance, minorities, nomadic people, especially those who are have itinerant lifestyles and would therefore have would have generations of non-registration of birth. And you will see that later within the Philippine context, victims of trafficking, among others. So when we talk about statelessness, it's not just in the migratory setting, but it's also in situ setting, meaning an individual could be living his or her whole life in one state, but would not be recognized as a citizen or a national of that state. So kumbaga, that individual is legally invisible to the eyes of the state. It's also important to note that not all stateless persons are refugees, although there are who are both. And the only durable solution to statelessness, unlike for refugees, which have several durable solutions, for stateless persons, the only durable solution is acquisition or confirmation of nationality. It's possible also for stateless refugees. For instance, the durable solution for refugees has already been fulfilled or achieved, but the individual remains stateless. So it's important again to also address that, because recognition as a refugee or stateless person is not an end in itself. Another group is on internally displaced persons, so persons or groups of persons who have been forced or obliged to flee or to leave their homes or places of habitual residence, in particular as a result of in order to avoid the effects of armed conflict, situations of general violence, violation of human rights, or natural or human-made disasters. And this is where the distinction between refugees and IDPs come in. They, unlike refugees, have not crossed an internationally recognized state border. So returnees are, given their name, are also people who have finally returned home. So how many are there? At the global level, based on the Global Trends Report of UNHCR as of end of 2020, there are 82,400,000 forcibly displaced worldwide. So we'd like to note that this figure does not include stateless persons and applicants, but they remain persons of concern to UNHCR, as mentioned earlier. So this figure is divided into two. You will see it on the right in blue, 26.4 million who are refugees, of which 20.7 are under UNHCR's mandate, and 5.7 million are Palestinians under UNRWA's mandate. For internally displaced people, there are 48 million, and of which 4.1 are asylum seekers, and 3.9 million are Venezuelans displaced abroad. So you will see here that 1.1 million new asylum claims were also filed in 2020. Developing countries hosted 86% of the world's refugees and Venezuelans displaced abroad, and these developed countries provide asylum to 27% also. So more than 2/3 of refugees come from just 5 countries: Syria, Venezuela, Afghanistan, South Sudan, and Myanmar. And a large population of these forcibly displaced individuals are also children. So it's important to view refugee protection and statelessness issues also from a gendered, diversity, or disability or culturally sensitive, as well as child protection perspectives. In terms of statelessness, in terms of the numbers, the quick answers were not sure. So based on the data from 94 countries, there are 4.2 million stateless persons. However, our observation is that this is a great underestimate because this only accounts for statistical data in certain countries. The estimates would be around 15 million. And again, children form a great part of these stateless persons. In every 10 minutes, one stateless child is born. So imagine in just this webinar, how many children are born stateless. And these are not their own fault. No, 70,000 stateless children are born every year, especially in countries hosting large stateless populations. So when we look into the framework or international refugee law. But before that, let me just highlight one last thing on on the statelessness data. Data collection remains a challenge, and one of the advocacies that UNHCR would have, along with other stakeholders globally, is to improve qualitative and quantitative data. So you have to be counted in order to count. And there is an ongoing effort by the expert group on IDP statistics on the development on handbook on status statistics, of which the Philippines is also one of the expert group's members. So moving forward, under international refugee law, so here we see the two main frameworks: the 1951 Convention, which defines the refugee, who a refugee is, outlines refugee protection principles such as the principle of non-refoulement, non-detention on account of being an asylum seeker or refugee, their rights and obligations, or their minimum rights and obligations, which should also be read within the framework of international human rights law, and the treatment in the country of asylum. for the 1967 protocol relating to the status of refugees, this removes the geographical and temporal limitations of the 1951 convention. So as mentioned earlier, the coverage of the mandate of UNHCR and the convention would only be limited to within the context of World War II. However, this protocol removes those limitations and thus makes it applicable to a broader range of refugee situations. So in terms of principles, there are three indicated here, but of course it's non-exhaustive. First is that everyone has the right to seek and enjoy asylum, but there is no guarantee that the individual is recognized or declared as a refugee. So the second is non-refoulement. This is also found in not just the 1951 convention, but also in other international instruments as well, wherein no one shall be returned to a place where his or her life or freedom is in danger. So this is the cornerstone of refugee protection, and it's also found in Article 33 specifically of the 1951 Refugee Convention. Refoulement does not necessarily happen only in countries of origin. So it can also happen in any place where an individual's life and freedom is in danger. So countries refusing access to asylum would also be considered as refoulement. In the Declaration of Territorial Asylum, it recognizes that the grant of asylum by the state to persons entitled to this is a peaceful and humanitarian act and cannot be regarded as unfriendly by any other state. So it's also important within the context now of the Afghanistan situation, wherein the UNHCR issued its position on non-returns to Afghanistan, wherein the right to seek asylum and the upholding of principle of non-refoulement was emphasized. So in essence, the 1951 convention provisions that are not linked to lawful stay or residence would apply to asylum seekers insofar as they relate to humane treatment and respect for basic rights, including non-refoulement. When it comes to an imminent violation of the principle of non-refoulement, there are mechanisms by which they could be addressed, such as human rights mechanisms, for example, the UN Special Rapporteur on Torture, the UN Special Rapporteur on Summary Execution, UN Working Group on Enforced Disappearances, and other treaty bodies as may be relevant. This may be related also again to the Afghanistan situation, noting that hindering access to asylum procedures may be considered as refoulement. Lastly, on non-detention, no one shall be detained on the basis of seeking asylum. Seeking asylum is not an unlawful act, and the detention of asylum seekers and refugees only on the basis of such or only because they seek asylum, or including if they enter the country without authorization, is not in line with international law. So, of course, there are also other principles that should be adhered to: the best interest of the child, confidentiality, do no harm principles, among others. So in terms of the question of can everyone become a refugee? No, but and everyone can seek asylum. They have that right. Is refugee status permanent? No. We look into certain instances. Now, for instance, exclusion clauses outlined in Article 1F of the 1951 Refugee Convention operates to disqualify persons from the benefits of refugee status by reason of serious transgressions that have been committed. So these clauses are related to the intrinsic links between the ideas of humanity, equity, and the concept of refugee, so as not to contradict the humanitarian and peaceful nature of the concept of asylum. So from this perspective, exclusion clauses would also help to preserve the integrity of the asylum mechanism. So here we also look at cancellation, no, in terms of the permanency of refugee status. This would mean that the decision should not have been granted, refugee status should not have been granted in the first place. When it comes to revocation naman po, no, this means withdrawal of refugee status in situation where a person engages in conduct which runs contrary to or is within the scope of Article 1F or Article 1FA or Article 1FC of the 1951 Refugee Convention. So this includes crimes against peace, war crimes, crime against humanity, or acts that are contrary to UN purposes and principles after being recognized as a refugee. And lastly, cessation, the ending of refugee status according to Article 1C of the 1951 Convention, because international protection is no longer necessary on certain voluntary acts of the individual concerned or, in certain fundamental changes in the situation of the prevailing country of origin. These three concepts, cancellation, revocation, and cessation, would also apply to stateless persons. But for cessation for stateless persons per se, it would only cease if the individual is able to, acquire or confirm his or her nationality. So again, there's only one durable solution when it comes to statelessness. So asylum is humanitarian in nature. So it's civilian in character. It's apolitical and impartial. It's a declaratory process considering the declaratory nature of the definitions of both refugees and stateless persons. And it is free of charge. So you'll know more about the specific process of the Philippines later on. So it will also emphasize these aspects. Also, just to highlight, these are also in line with the Universal Declaration of Human Rights, wherein seeking asylum is a peaceful and humanitarian act and cannot be regarded as unfriendly by any other state. So it is the responsibility of the country of asylum to evaluate a person's claim for such asylum. So we look into statelessness, and I hope you are still okay. First off, we'll look into the value or importance of citizenship. For me, when I started out, before I started in UNHCR, for me, it was just a piece of paper that indicates me as a Filipino. But for stateless persons, this is way more important than that. We'll look into this more later. But to emphasize, citizenship basically forms a bond or a membership between the individual and the state. So it's a two-way relationship. The individual has to perform its obligations to the state, while the state provides its protection to the individual or the citizen. While human rights in general are universal and are accorded to you by virtue of being human, nationality or citizenship, since we're going to be using them interchangeably, is an enabling right, meaning it's the right to access other rights, as termed by Hannah Arendt, who was who was a stateless refugee before, but I think has gotten American citizenship now. Before. So this means that having nationality or citizenship would lead you to access to services, right to participate in political affairs, and even reside legally in the territory of the state. So just to emphasize, nationality, as mentioned earlier, it's more of the sense of belongingness, while like for example, cultural ties or ethnicity, but citizenship is more of the legal aspect. Although, just to note, in different countries, they would use both terms, especially in multi-ethnic, multicultural states, but sometimes they would use it interchangeably or just use citizenship or nationality. So it again depends on the state and its respective framework. So when it comes to nationality and international law, so states have the power or can exercise its right to determine who its citizens are based on the 1930 Hague Convention. However, this exercise of right is not absolute, as it should be within the context, or it should adhere with international law. So later you'll see a list of international human rights instruments that provide the right to nationality. And nationality laws of different states would differ. It could be jus sanguinis or jus soli, jus sanguinis by blood. So, like the Philippines, for instance, it could be jus soli on the place of one's birth, like the United States, or it could be both in some instances. An individual may thus possess more than one nationality as easily as none at all. So, this is where statelessness would come in. In terms of the right to nationality, apart from the 1954 Statelessness Convention and its 1961 Statelessness Convention, it's accompanying framework, we'll look first into the right to nationality as enshrined in these frameworks. So these complement the Statelessness Convention, and this highlights how the right to nationality is also important within the context of migration for children in terms of gender equality on acquiring, changing, and retaining one's nationality and even passing one's nationality to their children. For persons with disabilities, non-discrimination aspect, acquisition or being granted nationality without prejudice to one's disability, as well as the elimination of all forms of racial discrimination or on the basis of racial discrimination. So here you see that statelessness, well, it's kind of a technical topic. It is a child rights issue, it's a women's issue, it may be an issue within the migratory context, among others. So, as mentioned, there are two statelessness conventions. The 1954 convention, it's quite long, so we just call it the 1954 Statelessness Convention or the 1954 convention. This is basically the twin convention of the 1951 Refugee Convention. So, similar to its twin counterpart, it defines who a stateless person is, as well as the rights accorded to stateless persons in terms of employment, social welfare, residence, naturalization, since the only durable solution for stateless persons is acquiring or confirming nationality, documentation, and freedom of movement. And it's important here to also highlight the value or importance of upholding these obligations, especially for state parties, since within the context of the pandemic, since the pandemic does not necessarily discriminate on whether an individual would have a nationality or not. So at present, there are 96 state parties as of September 2021 and would include the Philippines. On the 1961 Convention on the Reduction of Statelessness, or the 1961 Convention, this provides a menu of options for states to prevent and reduce statelessness. Excuse me. At present, there are 77 state parties, and the Philippines, while not yet a state party, has pledged to exceed the same in two global fora, 2011 Ministerial Intergovernmental Event, as well as the 2019 high-level segment on statelessness. So when we think about the 1961 convention, we think of it as a floor rather than a ceiling, because this just provides the minimum means by which, or safeguards by which statuses could be prevented or reduced. So, for example, foundlings. So, especially for states that use the jus sanguinis or citizenship by virtue of one's parentage, the granting of nationality for them, but also looking into other aspects of one's life. For instance, changes in one's personal status within the context of migration, state succession as well. So just a few more slides. We'll look into the causes of statelessness. So let's look first into discrimination. Discrimination is most of discrimination can be on the basis of gender, race, or ethnicity, among others. Most of 75% of the world's known stateless populations come from minority groups. So it could be, for example, on gender, There are several countries which prevent women from passing their nationality to their children or even their spouses, like the Philippines, or would have a separate procedure as opposed to acquisition of Philippine citizenship. There's also one country, if I'm not mistaken, wherein an unmarried father is unable to confer his nationality to their children. So a lot of the states are within the Asian Pacific, Sub-Saharan Africa, among others. It could also be within the context of race, like for example, the Rohingya, state succession, wherein changes in terms of the landscape of states. For example, an area belonging to another state would be transferred to another state, or combining two states, or dissolving a large state into two could cause individuals to be left behind. So there's also that direct discrimination there, wherein formation of a new state would consider other individuals as others, and that may leave them stateless or at risk of statelessness. So we'll also look into gaps or conflict in nationality laws. So this would look into um, like for example, on if there are no safeguards. For instance, if an individual migrates to another country, some states would consider that as a weakened connection between the state and the individual, and that could lead the individual to become stateless, especially if the individual is not aware of such gap or of such framework. It could also be conflict between the jus sanguinis and jus soli nationality laws. And lastly, on migration and displacement, it's combined here because migration and displacement could be a cause as well as an effect of statelessness. So it could also be like, for instance, when it comes to stateless persons, they may wish to move to another country or be displaced because of their status, but also migration and displacement by virtue of such events could lead to statelessness. Important also to emphasize that not all undocumented individuals are stateless. For instance, if a country utilizes the passport and is given only to nationals, for instance, you lost your passport. This does not necessarily mean that you are already stateless. You could just be undocumented because you are still recognized by the state as a citizen. So it's more of just renewing the passport, as opposed to other individuals who are not recognized by the state at all, or are at risk of statelessness because they have difficulties proving their links to the state. So just two more slides. The work of UNHCR and the work of the Philippines as well, you'll see later, is on four pillars. So we identify, look into the situation of stateless persons and at-risk populations, why they are such, what are the protection concerns, and then we lead into protection. Ensuring their access to services, meaning inclusion also. And again, this is very important within the context of the pandemic. This is also outlined in the 1954 Convention, which provides the minimum rights as well as other international frameworks. On prevention, this basically means avoid new cases from happening. So again, since the only durable solution to statelessness is on confirmation or acquisition of nationality, this could be through birth registration, safeguarding laws and policies, but also addressing how it is being implemented. Because again, statelessness could be a mixed question of fact and law. And lastly, reduction. So those that are existing are to be addressed, and also capacitating persons of concern in terms of the importance of citizenship and access to naturalization procedures. And I think this is also something that the Philippines has been doing, especially for our Sama Bajaws. So lastly, we have our global initiatives. This is a very non-exhaustive list because there are a lot of events that are coming up or have been done. So let's start off with the first. These are 2019 events in Geneva. This is the Global Refugee Forum and the high-level segment on statelessness. These are two different events wherein state, civil society, and other actors have made pledges on different areas, livelihood, cooperation, statelessness, among others. So this is being regularly monitored biannually. So if you also would be able to see, we can share the platform by which pledges are being monitored in terms of what has been done, what hasn't been done, and in relation to this, the upcoming high-level officials meeting would be an opportunity to monitor how these pledges have been implemented, also in line with the Global Compact on Refugees. So as you may know, this is a 2018 adopted framework, including the Philippines, which provides the blueprint to respond to refugee situations, but also noting that there are aspects there on statelessness, which highlights responsibility sharing and international cooperation in terms of refugee protection. The third is on the Cities with Refugees campaign. So highlighting not just at the national level, but also the importance of socially inclusive communities. So bringing together these communities to support refugees. And it also has, if you will see the website, you would also see there the Cities with Light, wherein good practices of these cities with cities who have manifested or signed their statement of solidarity to this endeavor have been highlighted. And I think, if I'm not mistaken, there are 250 plus cities around the world, with the Philippines having 13. So it's a very good endeavor. And also, in relation to this, there's also the coalition with Refugees Coalition. It's a global body which is composed of states, non-state actors, among others. And lastly, on statelessness, there is the Global Action Plan to end statelessness by 2024. So it's a 10-year plan and in line with the I Belong, #IBelong campaign. So basically, the I Belong campaign shares good practices, and the Global Action Plan is works within the 4 pillars of statelessness. So I think that ends my presentation. We would be more than happy to receive questions or comments you may have during the open forum. And with that, thank you for your kind attention.